You're watching the legal breakdown. So, Glenn, I want to work out here how the DC trial could still happen before the election. Let's do a bit of a thought experiment here. So, first, let's discuss the possibility that the Supreme Court rules on the immunity issue. What is the timeline for that specifically?
So, Brian, the question becomes, are they going to rule quickly or are they going to take their time? Now, we have one data point that they're willing to take their time because they set the oral arguments in this case for almost 2 months out, which I think raised lots of eyebrows of a lot of us legal analysts because they could have set it for 2 weeks down the road and resolved it promptly. But no, they said, we will hear oral arguments on the absolute immunity issue. And in the meantime, Judge Chutkan's case remains on hold, on pause in DC. That's Donald Trump's prosecution for trying to overturn the 2020 presidential election. They said, we're going to hear oral arguments, the week of April 22nd. That is a very long runway, but that is what they told the parties, the defense and the prosecutors. Okay, so let's assume the Supreme Court hears that argument the week of April 22nd and they resolve it quickly. Let's just arbitrarily pick May 1st. What does that mean? So let's assume she gets it back on May 1st and Judge Chutkan then puts it on her trial calendar for 90 days out. That would be August 1st. Given that the prosecutors estimated the trial would take about 6 weeks, what does that mean? It means we could have a verdict in the DC election interference against Donald Trump in the middle of September, still well in advance of the November election. Now, let's assume that the Supreme Court takes its time. They move slowly and they don't decide the absolute immunity case until the very last day of the Supreme Court's term, which would be June 30th. And then they return it to Judge Chutkan. Now, mind you, this thought experiment, Brian, has me assuming that the Supreme Court will rule a president is not a king. A president cannot commit all the crimes he wants against the American people to try to unlawfully and unconstitutionally retain the power of the presidency. And if he does, he can be prosecuted. Because let's face it, if the Supreme Court rules he does have absolute immunity, there will be no trial, there will be no prosecution. And in a very real sense, it will represent the end of our democracy, or at least give nefarious actors the blueprint to end our democracy, not hyperbole. So I'm assuming they're going to rule against absolute immunity, but let's assume they wait until the very last day of their term, June 30th. Then they decide it. Then they return it to Judge Chutkan. She again gives the parties that 90 days lead time that she suggested she would give them. Well, now we have a trial that doesn't start until October 1st. What's the problem there? 6-week trial puts the trial underway on election day in November. Now, I would rather have Donald Trump sort of convicted, have the case resolved one way or another before election day. But I guess the second best alternative is let that trial be ongoing while people are going to the polls, casting their vote for somebody who may, a couple of weeks after the election, end up a convicted felon. But, those are the two possibilities. If the Supreme Court resolves it quickly, we could have a trial of Donald Trump for what he did on and around January 6th, well before the election. If they resolve it slowly, it may be that trial is ongoing during the election itself.
Okay. Now, are there any other options here? Is there any way that they can push this even beyond the end of their term?
Yeah, great questions. There are a couple of footnotes that I would add to the discussion we just had. So, first of all, I said that the last day of the Supreme Court term is June 30th. Ordinarily, what the Supreme Court tries to do is rule on all of the cases in which they heard oral arguments during that term. And because their term ends on June 30th, they try to get all of the opinions out by June 30th, but they don't always succeed. Believe it or not, sometimes they have to carry over open cases and resolve them during the next term. So that would mean all timing bets are off, and there's no way that Trump could be taken to trial before the November election. The other thing they could do, this is a little bit of an outlier, but remember, when they decided to accept review of this case, what did they say? Here's the one and only issue the Supreme Court asked the parties, Donald Trump's lawyers and Jack Smith's prosecutors, to answer during that oral argument. They say, whether, and if so, to what extent, does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office. There is a little bit of a red flag in that question, Brian. What the Supreme Court wants to know is, were these official acts that Donald Trump undertook that he's now indicted for, or are they not official acts? Now, I would say any lawyer who knows what Donald Trump did on and around January 6th, indeed, any critical thinker, anybody who is able to engage in a fact-based assessment of what they see with their own eyes and hear with their own ears will be able to answer that question. No, these are not official acts. Therefore, he should enjoy no immunity. But because the Supreme Court phrased the question that way, here is the other footnote, and I know I've gone on a little longer than I wanted to on this topic, but the footnote is when a Supreme Court or any appeals court gets an issue of law that they have to resolve, but they feel like there are still some outstanding factual disputes or factual questions we, the appellate court, needs to have answered before we can resolve the legal issue. What they will often do, this is not unusual, the appellate court will remand it, send it back to the trial court with a direction. Hey, Judge Chutkan, we want to know if the 4 charges in the indictment involve acts that could be considered official acts, or are they not official acts? And what we're going to ask you to do is conduct an evidentiary hearing, make a ruling, whether they're official acts or not official acts. Then we want you to return the case to us, and then we will resolve the legal issue. So further developing the factual record is a real thing in appellate practice. My fear, Brian, is if the Supreme Court goes that route, I don't think they will. But if they do, that will mean months and months of additional delay. And we are not going to see Donald Trump tried for trying to overturn the 2020 presidential election until well into 2025.
Okay, well, let's go back to the first bulk, and let's say that the Supreme Court does rule in this term that Trump is not immune, which I do believe is the likely outcome here, even for a 6-3 conservative court, and it gets sent back to the trial track. Judge Chutkan did tell Donald Trump that he has 88 days, let's say 3 months, of preparation time, of lead time before the trial actually begins. Does she have to abide by that? Like, is that written in stone here?
Absolutely not. She could appropriately say, this case has lingered for quite some time. And even though it's been on hold, it's been on pause. Initially, I was prepared to give you 88 days, but I've reconsidered, and I'm going to give you 60 days. I'm going to give you 45 days. Those would be absolutely appropriate calls in the judge's discretion, especially because a lot of the legal issues have already been resolved. And the case really can proceed to trial with another 30, 45, 60 days of lead time. Now, Trump's lawyers will scream bloody murder. They'll accuse her of judicial misconduct. They'll say you lied to us. They'll say we relied on your promise to give us at least 88 days. But Brian, none of that will result in an appealable legal issue. So she could absolutely cut back on the time in the determination to get this case resolved in advance of an election when the people, the voters, will need to know what the outcome is before they cast their ballot in November.
Well, the irony of all of this is that they'll scream bloody murder if she cuts down that window from 90 to 45 days. All the while, they've used all of these nefarious processes to delay this thing until the ends of the earth. And that's totally fine. But God forbid Judge Chutkan cuts off 30 or 45 days from an already long window that she was going to give them to prepare for this trial in the first place. Like, talk about being graded on a curve.
Yeah, and let's face it, the people also have a right to a resolution of criminal cases in a timely manner. It's not as fulsome as a defendant's speedy trial rights, but we, the people, also have a right to have criminal cases resolved, because ordinarily it involves things like the vindication of rights of victims. And guess what? We are all American voters are victims. By statute, we're victims, because one of the counts involves depriving us of our voting rights. By statute, that makes us victims. We have a right to a timely resolution of these criminal charges, and I think we should be screaming bloody murder and asserting our right to a timely resolution of these charges.
Right. Glenn, does Judge Chutkan have to take into account the election? Like, is it her problem if Donald Trump is in the courtroom on election day itself?
Judge Chutkan actually is not permitted to take into account the election. Don't take it from me. Here is what Judge Chutkan said. I was at the status hearing when she said it. When the defense attorney kept pushing back on setting a trial date before the presidential election, she said she interrupted him and said, Mr. Lauro was the defense attorney who was making the argument. This trial will not yield to an election cycle, and we will not revisit the trial date. It doesn't get any more definitive than that. I think if Donald Trump ends up being in trial right through the November election, Judge Chutkan will not flinch because, as she said, the trial will not yield to an election cycle.
All right, Glenn, let's finish off with this. What about the longstanding DOJ position that there can't be any overt political act within 60 days of an election?
Yeah, it's a great question, Brian, because as somebody who was on the inside of the Department of Justice for decades, we do have a longstanding policy that we try not to do anything within 60 days of an election that could interfere in a free and fair election or could be perceived as partisan. So, for example, if we've been investigating somebody and an arrest has never been made for a very long time, rather than dropping an indictment on a political candidate for office in the weeks before an election, we might decide to wait until after the election so we don't interfere in the election or do something that could be perceived as partisan. The good news is both Merrick Garland, the Attorney General, and Special Counsel Jack Smith have directly taken on the implications of DOJ's 60-day policy very publicly. Merrick Garland said, once a case is in court, the 60-day rule no longer applies because we are literally on the court clock with respect to the run-up to a trial. Jack Smith just said the same thing in connection with the Florida prosecution over which Judge Cannon is presiding. He said, no, all bets are off on the 60-day clock, and we will continue apace in our criminal prosecution that's already up and running in court without regard to the coming election. So that's a little bit of good news.
All right, and I know that was supposed to be the last question, but Glenn, what are your thoughts on this idea of whether or not Judge Chutkan should allow this case to take place even through Election Day?
Absolutely. And, once she said this trial will not yield to an election cycle or to a campaign, I fully expect she is going to ignore Donald Trump's campaigning schedule. She's going to ignore Election Day because, these are really apples and oranges. These are separate branches of government. And, she has a case. Once she sets it for trial, all sort of extraneous factors like political campaigns should not impact her case moving forward in a timely manner. So I'm comfortable with it. In fact, I think we should insist on it because the last thing you want to do, Brian, is to kind of keep the gloves on and treat a political candidate with kid gloves and give him the opportunity to steal another presidential election. It makes sense to me that the case should be resolved and the American voters should have a full appreciation of who they're casting their ballot for come November.
Perfectly put. We'll leave it there. Obviously, a lot to stay on top of, and things are, changing by the day. So for everybody watching, if you want to follow along with whatever happens, please make sure to subscribe. The links to both of our channels are right here on this screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.